And by the power of technology, Manisha has turned into Malcolm. Welcome, Malcolm.
Thank you, Simon. Glad to be here.
So, yeah, just by way of introduction, Malcolm Padiachi looks after our liability and professional indemnity divisions. He's going to be just giving us his insights from the survey and the professional indemnity environment in particular. Malcolm, I think it would be remiss of us not to look at these numbers from an incurred claims perspective. After Gareth's talk earlier, I think there was quite a big focus on how the loss ratio really has developed related to PI in particular. What do you expect to happen? Because again, you know, much like we saw in the liability environment, it does appear that there's been a significant drop in incurred claims between 2018 and 2019. Can you just kind of talk us through, firstly, what is causing that?
So Simon, I think firstly, you know, it's too early to draw any conclusions from these early years. I mean, as Gareth explained in his presentation earlier, our empirical, and it's common knowledge that PI claims are long-tailed in nature. You know, our empirical data shows, you know, from the last 35 years that we've been in business, that PI claims generally take about 16 months to mature. So that's a period of 5 years in which full maturity of any particular year of insurance, you know, presents itself. So it's too early to draw any firm conclusions from that, because definitely these years that as displayed on that slide will develop as we going along. You know, despite the fact that we have, you know, robust reserving philosophies, as Anton mentioned earlier, you know, with Manisha, that as and when facts develop in a case, changes the way a claim is looked at and the way you know, we settle it. So the other factor that contributes to this decline is probably due to the fact that, you know, we've recently, well, not recently, since early 2018, adopted a very robust and aggressive re-underwriting, repricing strategy. As a result of which we looked at our book, which was, and as Gareth mentioned in his presentation, you know, the PI part of the business was the most distressed book of business. We had to re-look at the business, clean out the books, you know, gave notice on accounts that didn't quite fit our appetite, which historically we took on from an accommodation basis, and due to the elements of being a victim in the soft market cycle. And you know, as a result of that clean out that I've mentioned, you know, we've lost a lot of policies, and the majority of the policies that contributed to the distressed PI was largely in the built environment, and the built environment involves anybody that's involved in the construction side, including, you know, the law firm. Subsequently, you know, we'd re-looked at those portfolios, and we weren't successful in securing it or retaining it because of the way we re-underwrote the risk and increased and restricted covers. And we have the significant absence of those risks in our portfolio. So that could, you know, also contribute to the fact that we're starting to see a drop in claims volumes. But I do think, though, that these years will develop as claims mature. Thanks.
Thanks so much, Malcolm. Anton, from you, I mean, you're seeing a drop in claims volumes. Are we still noting that the environment is, because I'm assuming we still have built environment clients on our books, we're still handling those claims. Are you noticing any trends there?
Simon, yes, look, we deal with each one of these claims on its own merits. And I mean, insofar as trends are concerned, we are experiencing quite a number of claims where, you know, professionals are simply seen as the last line of to try and get some money back, you know, whether it's legitimate or not. And we are seeing professionals being accused of negligence across the board, even for, especially in the built environment, where certain contractors, especially what we've seen lately, is various contractors, you know, either going into business rescue or, you know, liquidating and so forth. And, you know, course, gone, the only person left standing is the individual, and of course, that individual has got PI cover in place. And so we're seeing a push towards claims being made against these individuals simply because of the fact they're around and that they have insurance policies in place. We have thus far had a very good track record in defending these individuals, but what we are seeing is that the defense cost at the end of the day exceeds the original claim. So that's definitely a trend that we picked up over the past year or so.
Okay, let's sorry, can we look at the next slide, please? So I found this interesting. So we asked all the professionals that were in our survey, and I think there were some 200 odd, maybe a little higher than that, if they'd actually had a personal negligence claim in the 2 years prior to the survey. And then we sort of overlaid that with our own claims experience, looking at the number of professionals we've got on our portfolio and the claims that have been lodged against them. And the number it's almost double in our experience. What would the reason be for this disconnect, Malcolm?
Simon, yeah, I think there's a few factors that affect this. Firstly, obviously the respondents that we interviewed, not all of them are our clients. We at SHA, from a PI perspective, have thousands and thousands of PI policies. I think at last count, it was around 6,500 or 7,000 PI policies, excluding schemes that we have. We have schemes where, there's many hundreds of policies within the schemes. So it stands to reason then that, with so many policies that we have at SHA, we would have, double the numbers of claims intimated than our respondents would have indicated. The other thing is, I suspect that, and this has been an issue for a while, is the issue around the requirement of notifying claims to an insurer, and a misunderstanding in respect of clients as far as PI policy is concerned. And that there is a real issue out there in that clients only perceive that they're required to notify a claim in terms of the PI policy only when they receive a letter of demand or a summons. I mean, all PI policies that's available in the market, locally and internationally, require that the insured notify a circumstance or intimation of a claim, however remote it may be, to your insurer, so that we are able to look into the claim and not prejudice either the insured's position or the insurer's position. And I think that misunderstanding also speaks to the low percentage of negligence claims as well. That has been indicated by the respondents in the survey.
Thanks. Anton, would you expect this to change?
Simon, no. I mean, I fully support what you're saying. And I think, what we are seeing as well is lots of times the professionals who are working on a specific contract don't believe that there's going to be a claim. So, they need to interact with their brokers whenever there is something like this. But I think at this point in time, there's still the old type of approach of, well, no one will sue me and, I'm doing my work right. So, they don't foresee anything. But the problem is that, with consumer activism where it is, lots of people are now pushing for these claims. So it could be that the survey results were just simply the individual. I don't believe anyone will sue me. And sadly, at some other stage, someone will. That's the reality if you look at our stats.
So Simon, can I just maybe just highlight the important point here, to our brokers out there, that they need to indicate to their clients the importance of notifying circumstances so that they don't fall foul of the notification provisions under a PI policy. And it's not only in respect of a SHA policy, all PI policies have notification conditions on it. And, if a client fails or delays in notifying potential claims, they could fall foul of those provisions and have a potential claim denied or rejected. Thanks.
Yeah, thanks, Malcolm.
Sorry, Simon, just also to add in there, because this is an exceptionally important point that Malcolm raised. From the claims side, it's always very difficult to try and reconstruct the facts surrounding these highly complex claims if we are not involved from day one. So, in certain cases, we've seen that, the time the summons hits, whatever, employees have changed. Lots of things have changed. The contracts have been destroyed. All kinds of issues like that. So, just to confirm, if we the earlier we are involved, the better the chance of sorting out the matter without any potential problems, and of course, with our insured claim rejected, which is something that we don't really want to do. But if something like this happens, the contract reads the way it does. So please engage with us. If there's uncertainty, rather phone me or my team, and we'll certainly try and help in deciding how to proceed with the incident.
That's good advice. I just want to share with the brokers, out of the 200 odd brokers that we spoke to in the survey, around 90%, I'm rounding off here, said that they didn't believe their clients read their policy documents. So I mean, it's just kind of reinforcing what you're saying. Probably that notification clause is not even getting looked at, and I guess it falls on the broker to explain these things to their clients. Can we move on to the next slide, please? Okay, so I think this is an encouraging number. I looked at it slightly differently when I saw it. 80% of professionals that we surveyed said that they have PI cover. But Malcolm, you kind of looked at this a little differently. Like, 1/5 of the guys don't have cover. What do you make of that?
Yeah, I mean, Simon, that's a shocking stat. 20% of the respondents indicated that they don't have PI cover. Any business, and not only in the professional space, any business that offers a service or provides advice, be it for a fee or not, incurs a potential PI liability. And I always use the analogy that any business operating with PI insurance, whether it's a standalone PI policy or an extension under your general liability, is like playing Russian roulette, a hit and miss. Because just an allegation of negligence against the firm from a litigation point of view could have dire consequences to the firm. From a cost point of view, going through an entire litigation could potentially bankrupt any firm or company. So the importance of PI insurance is primarily, a defense cost policy, defending you as to any allegations made against you, be it valid or not. And it's primarily there as a defense cost policy. Yes, it does cover you in the event of any liability attaching to you, subsequent to settlement or a court award, but primarily it's for defense. And it's critical that every company, and not only professional companies, have PI cover in place.
Yeah, thanks,
yes, no, I fully
Malcolm. Just
that.
Next to that, Anton?
Sorry, Simon. I just wanted to add in that, in addition to this, they must have cover, but they must make sure that they have adequate cover. So they must get advice from their broker as to, what limits and stuff like that to buy. Because we have seen matters in the past year where they would buy a limit of R1 million and the defense cost exceeded the R1 million within 9 months. So it's exceptionally important to get that advice and to buy the correct limit as well.
I hear you, and actually that speaks to the infographic just next to that one, where 27% of the guys that do buy the cover said that they only buy it because there's some kind of rule or regulation forcing them to do it. How dangerous is that motivation for buying insurance, Malcolm?
Yeah, absolutely. It's extremely dangerous. One can assume that for those individuals, they either don't understand what a PI policy covers, don't understand whether it would cover them to protect their business against, professional negligence claims. They could also be uninsured, uninformed about what would be the correct limit of indemnity to carry. If the regulation calls for R1 million cover, as Anton expressed, they would take out R1 million cover, but their business is totally, potentially exposed to multitudes of that R1 million cover. So it's a massive risk from not understanding what the limits and the cover that a PI policy operates.
Yeah, thank you. Can we move on to the next slide, please? Okay, this was a bit surprising for me. I don't know, I don't recall what the numbers were here, but we seem to have seen a spike in claims against OCTs. Anton, what would the reason for that be?
Simon, in short, looking at the most of these claims, the architect will act as a principal agent or project manager. So they coordinate everything, they make sure everything works with them. The problem is that, and I mentioned this earlier, where you have a contractor that, for poor workmanship or whatever else, the architect is seen as the go-to person for everything and the responsible person for everything, which obviously, even in terms of their contracts, it's quite clear that they aren't responsible for everything. They are only responsible for their designs and everything else. And then, of course, the other professionals and the contractors, whatever, are responsible for their portions. However, what's happening is that the third parties just puts the architect in their firing line, and that's it. You're responsible for anything that happens. And again, the increased risk here is, because of what we saw in the last year with COVID, lots of the smaller companies either going into business rescue or being liquidated. There's no more contractor to sue, and then they just go simply architects. So lots of the stuff that we've defended successfully. But of course, the cost associated with it is very, very exorbitant. If I could, not exorbitant, but it's quite high. And it's still, at the end of the day, is money that's spent, and it's not money that we're going to get back.
Yeah,
I think I saw in the report it was 9 million or something. Yes, sorry, Malcolm.
Yeah, just to add on to what Anton said, and I just want to qualify those stats a bit, is that yes, although we are seeing an increase in claims against architects, because generally what happens on a construction site, when something goes wrong, the owner of the project looks for reimbursement from the entire professional team, and naturally the architects gets drawn into those disputes as well, which then activate this PI policy, and we'd have to defend him, against those allegations. But the particular large spike on the architect's claim was largely due to one claim, which was developing for quite a while now against an architect, where he was sued. We defended him because he believed, and we had experts supporting that he wasn't negligent. And we went all through the court systems. We won at the lower courts. The claimant then appealed to the superior court, and we won again in the superior court. So as you can imagine, the litigation cost itself there almost, fortunately he had enough limit of indemnity, but it almost eroded his limit of indemnity. So the cost aspect, again, is another critical point, is that make sure your insureds have adequate limits of indemnity, when purchasing PI insurance. So it was largely due to, one claim, but there's certainly an increase in claims against architects. The other trends that we're seeing against architects is, in this depressed economy, when projects run over costs, they look to the architect for cost overrun type claims, because the architect is responsible, for monitoring that and ensuring that, these projects are delivered in time and within budget. So he naturally gets dragged into these type of disputes as well.
Yeah, correct. Thank you. Thanks, guys. I noticed in the report, I'm not going to ask you to comment, I'll just direct brokers to take a look at it, but largely influenced by COVID, but not only. We saw that a lot of professionals were taking on new tasks a little bit outside of their normal professional activities, and obviously that comes with a significant exposure. In this year's report, just over 50%, which matched kind of what we were looking at last year as well. Can we move on to the last slide, please?
Sorry, I know you said you didn't want to comment, Simon, but can I comment on the previous slide quickly on that? Just
for the audience's benefit, Malcolm is a lawyer, which is why he's quite keen to keep talking. But
I'm quite passionate about the subject. I don't know how we're doing for time. Yeah. But the concern for me here is that consulting firms, and I'll speak again in the built environment, because that's where the most demand for PI insurance is that I'm finding consulting firms are pivoting their business to obviously gain income or other streams of income in a depressed economy. But the concern is, it's a general known fact that we have a skills drain in South Africa, where, there's a massive gap between the experienced professionals and the newer professionals coming out of the universities. And in between, there's a massive gap because professions or professionals have either exited the business due to depressed economy or have emigrated to seek greener pastures. And that skills gap is concerning because we're now pivoting to take on other scope of activities to gain additional income. But do we have the skills to undertake that? And that's where mistakes come in. That's where PI claims come in. And that's the massive concern that I see, with that stat. Thanks.
Fair points. Thank you. Next slide, please, guys. Just 1 minute each of you as a wrap up. Things that we should be looking toward in 2021. Any trends? Anything that we should look out for? Malcolm?
Yeah, just quickly for me again the issue of the skills gap, the brain drain in South Africa. We all know government in trying to resuscitate the economy has pledged enormous amounts of money for infrastructure development to kickstart the economy. The problem is, once that gets off the ground, do we have the skills to support and deal with those large projects, infrastructure projects that's going to get off the ground now? And when you don't have the skills, we have a situation where everybody's hungry for the work. It becomes a pricing competition. You're tendering at cheaper prices, and when you do get awarded at a lower price, you don't dedicate the resources that you would normally dedicate when you charge the correct fee. And that's where you get issues around corners being cut, mistakes creeping in, PI claims. And then as you see from Garrett's email, the PI claims trends have just gotten out of a kilter with the rates that we've been charging historically as well. So we just need to make sure that we charge appropriately for the risks, and that insureds in turn ensure that they have proper risk management protocols in place to avoid these type of mistakes and claims coming in. Thanks.
Thanks, Malcolm. Anton, from you, particularly claims on the horizon?
Simon, we don't foresee anything, any major changes so far as actual claims are concerned. Based on our historic stats, we don't foresee anything materially new coming into the equation. But I just want to mention that we are seeing is that there's a material increase in legal costs, and furthermore, with some of these matters, they are becoming exceptionally complex and complicated. Attorneys at a higher rate are spending more time on dealing with these matters. So it is just that's one of the trends that we're seeing within this space. So that I just want to bring that to the table.
Thank you. I think to your point, we saw a 56% increase in fees between 2016 and 2019, way above the inflation rate. So yeah, thanks for that.